Land Titles and Deeds, Chapter 1. Historical background of land registration in the Philippines, adoption of Torrens system of land registration, Regalian Doctrine. First, we have the historical background of land registration. Here we have a timeline starting with November 6, 1902, when the Philippine Commission enacted Act No. 496, otherwise known as the Land Registration Act, which provided for three things: the creation of the Court of Land Registration, the offices of the Register of Deeds, and the institution of the Torrens system of registration in the Philippines. In February 1, 1903, the Torrens system took effect, and the present Land Registration Authority is said to have taken roots on this date as well. February 16, 1976, the Presidential Decree No. 892 was enacted, abolishing the system of registration under the Spanish mortgage law. All holders of Spanish titles were given until 6 months, or August 16, 1976, to register under the Land Registration Act. And lastly, on June 11, 1978, the Property Registration Decree was signed and promulgated to amend and codify the laws relative to the registration of property, as well as to strengthen the Torrens system. Now that we know the rich history of land registration in the country, let's find out the purpose of the adoption of the Torrens system.
The province of South Australia was created by an Act of the British Parliament in 1834. 2 years later, a group of colonists under Governor Hyde-Marsh arrived from England. From the beginning, there were land troubles. Blocks that had been sold were not available when the colonists arrived. The survey plan was lagging, as Colonel Lapp, the surveyor, was short of staff and equipment. With the arrival of fresh immigrants, land was in demand. Many colonists subdivided their blocks, hoping to make large profits. Properties changed hands often. Each time land was sold, a deed of conveyance had to be prepared. South Australia had inherited the English common law system, by which records of land transactions such as deeds, mortgages and leases accumulated. All these were needed to prove ownership or title to the land. A good title depended on a succession of indisputable documents. If a deed was missing, the title was in doubt. The buyer's solicitor had to examine all documents to guard against fraud or error. This examination was time-consuming and expensive. Solicitors' bills often amounted to more than the cost of the land. Robert Richard Torrens was the son of one of the founding fathers of the colony of South Australia, Colonel Robert Torrens. He was responsible for the introduction and early implementation of the Torrens title system of land certification still used in many parts of the world. On this single certificate, all transactions for the property are registered: transfers, mortgages, leases, and so on, with this registration guaranteed correct by the state. The certificate of title is prepared in duplicate. One remains with the Registrar General, and the owner keeps the other. In 1852, Torrens was made Colonial Treasurer and Registrar General. As Registrar General, he found the need to reform the system of land conveyancing acutely urgent. He had the idea of using the same method to transfer land as was used in the selling of ships. Here a single document gave continuing proof of ownership. The 1857 elections were drawing near, and Torrens was standing for Parliament. He made land title reform the main electoral issue. When the results were announced to the citizens of Adelaide, Torrens headed the polls. And so, Robert Richard Torrens became a member of South Australia's first elected Parliament. Torrens first introduced his bill to amend land titles in May of 1857, and, after much debate and opposition, it came to the final vote in December. The bill was passed by Parliament, and there was much rejoicing by the citizens of Adelaide. And so, on the 27th of January 1858, the Real Property Act became law. Robert Richard Torrens also helped the introduction of the Torrens title system to other Australian states and New Zealand. Since then, the principle of the Torrens title system of land registration has spread throughout the world. Over the years, methods have been modernised, but the principle remains the same: a single indisputable certificate of title filed in the Land's Title Office, and an identical one held by the owner. For these benefits, Australia and the world have much to thank Robert Richard Torrens.
Okay, as we've seen in the video, the Torrens system was coined after Sir Robert Torrens, a layman from South Australia, and indeed we have a lot to thank him for. In the Torrens system, the title by registration takes the place of title by deeds under the system of general law. The purpose of its adoption is to do away with the delay, uncertainty, and expense of the old conveyancing system. It's also meant to guarantee the integrity of land titles and to protect the indivisibility of the titles. The Torrens system seeks to ensure the efficacy and conclusiveness of the certificate of title. This means that every person receiving a certificate of title in pursuance of a decree of registration and every subsequent purchaser shall hold the certificate of title free of all encumbrances except those noted on said certificate. To better understand the Torrens system, the terms title and certificate of title must be defined, of possessing that which is ours. On the other hand, the certificate of title is regarded as a mere evidence of ownership and not the title to the land itself. Under the Torrens system, a certificate of title may be an original certificate of title or the OCT or a transfer certificate of title or the TCT. The real purpose of this system is to quiet title to the land. This essentially means that once a title is registered, the owner may rest secure without the necessity of waiting in the portals of the court or sitting in the mirador de su casa to avoid the possibility of losing his land. The only exception to this rule previously mentioned is when a person obtains a certificate of title to a land belonging to another and he has full knowledge of the rights of the true owner. The said person is considered guilty of fraud, and according to the case of Angeles versus Sanya in 1938, he may be compelled to transfer the land to the owner so long as the property has not passed on to the hands of an innocent purchaser. Therefore, we can say that land registration under the Torrens system is a judicial proceeding and it's final and binding upon all the world. It is an action in rem.
The effects of registration under the Torrens system. A registered title cannot be altered, modified, enlarged, or diminished in a collateral proceeding, and not even by direct proceeding, after the lapse of the period prescribed by law. While the proceeding of the registration of land under the Torrens system is judicial, it involves more in its consequences than does any ordinary action. All the world are parties, including the government. Advantages of the Torrens system. First is it has substituted security for insecurity. Second, it has reduced the cost of conveyances and the time involved. Third, it has changed brevity and clearness for obscurity and verbiage. Fourth is it has so simplified ordinary dealings that every man of ordinary literacy can transact his own conveyancing. The perceived advantages of the Torrens system of registration of land titles have helped stabilize land ownership in the Philippines. Its underlying principle is security with facility in dealing with land. Its fundamental purpose is to quiet title to land, to perpetually enjoin any question in the legality of the title. Hence, the titles issued under the system are indefeasible. Another advantage of the Torrens system, it affords protection from fraud. Um, it has restored to their just value many estates held under good holding titles but depreciated as a result of some blur or technical defect and has barred the recurrence of any similar faults. These are the rights of innocent third persons. Every person dealing with registered land may safely rely on the correctness of the certificate of title. The main purpose of the Torrens system is to avoid possible conflicts of title to real estate and to facilitate transactions relative thereto by giving the public the right to rely upon the face of the Torrens title and to dispense with the need of inquiring further, except when the party concerned has actual knowledge of facts and circumstances that should impel a reasonably cautious man to make further inquiry. Registration as the operative act that validates conveyance of land. Registration is the operative act that gives validity to the transfer or creation of a lien upon the land, according to sections 50 and 51 of the Land Registration Act. Consequently, where there was nothing in the certificate of title to indicate any cloud or vice in the ownership of the property or any encumbrance thereon, the purchaser is not required to explore further than what the Torrens title upon its face indicates in quest of a hidden defect that may subsequently defeat his right to the property. The following are the exceptions to the rule. The purchaser or mortgagee has knowledge of a defect or lack of title in the part of the vendor. The purchaser is an investment and financing corporation which is presumed to be experienced in business with expertise in mortgage and sale of registered land in order to ascertain that there are no unauthorized persons in possession of the property. Probative value of the Torrens system. The following are precedents with regards to the probative value of the Torrens title. First is, a Torrens title is generally a conclusive evidence of the land, according to Ching versus Court of Appeals, 1990. And second is, mere possession cannot defeat the title of a holder of a registered Torrens title to real property, according to J.M. Tuazon Incorporated versus CA, September 11, 1979. And third is, the certificate of title serves as evidence of an indefeasible title to the property in favor of the persons whose name appears therein, referring to Ibanez versus IAC, March 6, 1991. Next is the mirror doctrine. The mirror doctrine under the Torrens system echoes the doctrinal rule that every person dealing with registered land may safely rely on the correctness of the certificate of title, therefore, and is no way obliged to go beyond the certificate to determine the condition of the property. Curtain principle. Synonymous to the mirror doctrine is the curtain principle, which is one of the guiding tenets underlying the Torrens system, in that one does not need to go beyond the certificate of title because it contains all the information about the title of its holder. This principle dispenses with the need of proving ownership by long, complicated documents kept by the registered owner, which may be necessary under a private conveyancing system, and assures that all necessary information regarding the ownership is on the certificate of title. These are the exceptions to the rule, or exceptions to the rule and the doctrine. When the party has actual knowledge of facts and circumstances that would impel a reasonably cautious man to make such inquiry. Second is, when the purchaser has knowledge of a defect or the lack of title in his vendor, or of sufficient facts that induce a reasonably prudent man to inquire into the status of the title of the property. The presence of anything which arouses suspicion should then prompt the vendee to look beyond the certificate and investigate the title of the vendor appearing on the face of the said certificate.
For the icebreaker, watch this short clip.
That I cannot do.
I'll give you anything you ask.
We've known each other many years, but this is the first time you ever came to the council for help. I can't remember the last time that you invited me to your house for a cup of coffee. Even though my wife was godmother to your only child. But let's be frank here. You never wanted my friendship. And you were afraid to be in my debt.
I didn't want to get into trouble.
I understand. You found paradise in America. Had a good trade, made a good living. Police protected you, and there were courts of law. You didn't need it from that. But now you come to me and you say, I'm Corleone and give me justice. But you don't ask for respect. You don't offer friendship. You don't even think to call me Godfather. You said you'd come into my house on the day my daughter's to be married and you asked me for murder. Money.
I ask you for justice.
That is not justice. Your daughter is still alive.
Let her suffer then. She suffers. How much shall I pay you?
Buonasera. Buonasera. What have I ever done to make you treat me so disrespectfully? If you'd come to me in friendship, then the scum that ruined your daughter would be suffering this very day. And if by chance an honest man like yourself should make enemies, then he would become my enemies. And then they would fear you.
Be my friend. Godfather.
Good. Someday, and that day may never come, I'll call upon you to do a service for me. But until that day, accept this justice as a gift on my daughter's wedding day.
Grazie. Yes, right.
Great.
Moving forward, Regalian Doctrine. The previous clip is about the Godfather. Imagine that the Godfather is like the state. It would be explained further. First, the concept of ownership. Under Article 712 of the New Civil Code of the Philippines, ownership is acquired by occupation and by intellectual creation. Ownership and other real rights over property are acquired and transmitted by 1. By law, 2. Donation, 3. By testate and intestate succession, and 4. In consequence of certain contracts by tradition. There may also be acquired by means of prescription. In relation to acquisition and transfer of ownership, it should be noted that sale is not a mode, but merely a title. A mode is the legal means by which dominion or ownership is created, transferred, or destroyed. But title is only the legal basis by which dominion of ownership is created. Contracts only constitute titles or rights to the transfer or acquisition of ownership, while delivery or tradition is the mode of accomplishing the same. It means tradition or delivery transfers ownership. Under Article 49(6) of the said code, the ownership of the thing sold is acquired by the vendee from the moment it is delivered to him in any way specified in Articles 49(7) to 1501, or in other manner signifying an agreement that the possession is transferred from the vendor to the vendee. It means that the word delivered should not be taken restrictively
to mean transfer of actual physical possession of property. Why? Because the law recognizes two principal modes of delivery. One, actual delivery, and second, legal or constructive delivery. Actual delivery means placing the thing sold in the control of possession of the beddee, while legal or constructive delivery done by means of execution of a public instrument evidencing the sale. Second, by symbolical tradition, such as the delivery of the keys of the place where the movable sold is being kept. Third, through traditio longa manu, or by mere consent or agreement if the movable sold cannot be transferred to the possession of the buyer at the time of the sale. Fourth, it's about traditio brevi manu, or the buyer has the possession of the object even before the sale. And finally, by traditio constitutum possessorium, it means the seller remains in possession of the property in a different capacity. Moving forward, about ownership rights over public lands. It is acquired from the government either by purchase or grant. Otherwise, the lands that were not so acquired shall be presumed to belong to the public domain in accordance with the Regalian Doctrine. Exception to this rule is any land that should have been in the possession of an occupant and of his predecessors in interest since time immemorial, for such possession would justify the presumption that the land had never been part of the public domain or that it had been a private property even before the Spanish conquest. It is cited in Carino versus Insular Government. What is the meaning of time immemorial? Time immemorial is defined as a period of time which as far back as memory can go, but not beyond the pre-Spanish conquest period when the Regalian Doctrine was not yet introduced and adopted in the Philippines. The basis for land title is first, native title is acquired through ancient possession of the land which never became public land at all, while the imperfect title means that it is acquired through the occupation of agricultural public land for the requisite period. The pre-Spanish conquest rights of the land and domains held under the claim of private ownership by Filipinos as far back as memory reaches. Lands acquired through native title are deemed never to have been public lands, since they are indisputably presumed to have been held the way before the Spanish conquest. Again, imperfect title is the right of the land, alienable and disposable land of the public domain acquired by an individual by operation of law. How imperfect title is acquired? It can be acquired by possession and occupation by a person and his predecessors' interests for the period required and considered by law sufficient as to have segregated the land from the mass of public land. It means when a person is said to have acquired an imperfect title by operation of law, he acquires a right to a grant, a government grant to the land without the necessity of a certificate of title being issued. As such, the land ceases to be part of the public domain and goes beyond the authority of the state to dispose of. An application for confirmation of title, therefore, is but a mere formality. Now we proceed to the real definition of Regalian Doctrine. It is written in our Constitution. Section 2, Article 12 of our Constitution states that all lands of public domain, waters, minerals, coal, petroleum, and other mineral oils, all sources of potential energy, fisheries, forests, or timber, wildlife, flora, and fauna, and other natural resources are owned by the state. It means it shall be under the supervision and control of the state. The basis of the Regalian doctrine is the Recopilación de Leyes de las Indias, which means that all lands, territories, and possessions pass to the Spanish crown, the state, in lieu of the king. Since before, our country was colonized by the Spaniards, and now we are governed by the state, which means the state is the owner of all land and waters of the public domain. Therefore, the Regalian doctrine is the foundation of the time-honored principle of land ownership, that all lands that were not acquired from the government, either by purchase or by grant, belong to the public domain. It is further specified that the following things are property of public dominion under the new civil code. First, those intended for public use, such as roads, canals, rivers, torrents, ports, and bridges constructed by the state, banks, shores, roadsteads, and other similar character. Second, those which belong to the state without being for public use are intended for some public service or for the development of the national wealth. To summarize, we present some key takeaways.
The first takeaway is that the Torrens system seeks to ensure the efficacy and conclusiveness of the certificate of title.
Second is, the certificate of title serves as evidence of an indefeasible title to the property in favor of the person whose name appears therein.
The Regalian doctrine substantially states that all lands of the public domain presume to belong to the state.